This chapter will give examples of laws that can lead to an arrest for inappropriate anger. There may be more than I list here, but these are the ones I see most often in my work. Sometimes there can be several laws broken at the time of the incident. If arrested, those broken laws become counts against the individual. An example could be Count 1, domestic violence, Count 2, terrorist threats, Count 3, false imprisonment, Count 4, child endangerment, Count 5, keeping someone from making a 911 call. All of these can be used in court. Many times some counts are dropped in the plea bargaining process with the idea that the person will accept the deal. If the individual violates the deal, the court may choose to bring them back to court and try to prosecute the individual for the laws broken during the initial arrest. Take note here, the court can often get involved quicker than one ever imagined. Obviously, domestic violence frequently leads to an arrest and judgments in criminal court. Courts also get involved when Children's Protective Services has a case and when there is a custody case in family court. Although violence in a relationship is known to be taboo, it often happens. After the violence, the offender may not want the relationship to end and apologizes. A promise is often made that it won't happen again. The offender usually doesn't want others to know and will often tell his partner not to tell anyone, not wanting to be known as someone who has out of control anger. Without getting help, this apology and promise usually don't work. In horribly dysfunctional relationships, not only does the offender try to justify their violence, they often get with other acquaintances who support those same beliefs. You know how women get. What else could I do? They just kept pushing my buttons. If he talked to me that way, I would have done the same thing. A lack of confidence or self-worth for either partner, especially as it relates to a relationship, can lead to such emotional drama that the word relationship can take on the same meaning as my property. An example is she's mine or he's mine. Many times, the hurt from past poor relationships, along with the experience of growing up with a lot of dysfunction, can become the foundation on which future beliefs are built, and how unhealthy anger is wrongfully justified. Violence from either partner is unacceptable, no matter what the reason. Having said that, often both the offender and the victim come up with false truths about the incident. An offender might say, I was intoxicated, I was frustrated, I've had a lot of problems lately. If you hadn't said what you did, I wouldn't have hit you. You weren't hurt that bad. What else was I supposed to do? I told you to stop. I told you what would happen if you ever blah blah blah. Anyone would have done the same under the circumstances. You wouldn't let me leave, so I had no other choice. A victim might say, he or she isn't always like that. They were on drugs. They were drunk. He or she didn't mean it. I should have stopped when he or she said to. He or she is right. I'm partly to blame. That's just what we do when we get mad. Even with serious violence in the home, many victims do not call for help. There are definitely more reasons, but these are three big ones. 1. There's an unwritten code that you don't call the police or go to a hospital. Yes, violence is bad, but those people will make things worse. I could lose my kids. We won't have a place to stay. Where would I go? And more. Number 2, the person is so psychologically and physically beaten down that they literally believe terrible things will happen if they make a report to authorities. Some of these individuals have heard comments like, I will take you out. I will kill the kids. You will never see your kids again. Wait till they hear what I have to say about you. I will always find you. I will call all of you, then myself. I will kill myself if you tell. Add to this the frequent news reports about someone who did just what was threatened, and you can see how someone could come to believe these threats. Then there is 3. They say they love this individual. Comments like, all relationships have good and bad. When it's good, it's good. When it's bad, it's bad. But good comes back. We're married. She's been there for me in the past. All of these rational lies are very unsafe and unhealthy. The participants usually know people who have died or experienced serious injury as a result of violence. They usually know it's bad for the children. They usually know about CPS and that they could lose their children. They usually know people who continued to make bad choices and ended up in prison. Although most of the participants know it's a matter of time before more serious problems arise, they unfortunately all too often continue with their current belief system. Others recognize this need for change and will either end the relationship or work to restore it. The courts do not like children exposed to violence in the home. Many naive parents will say that children were not the target of the violence, yet will admit that the children will be negatively affected by witnessing it. Not only can the offender go to jail after there is an arrest for inappropriate anger, they may find it very difficult once they are out or before it goes to criminal court to have quality time with the children. Often, even before a criminal case is heard, family court will take the offender's parenting rights away when there is sufficient reason to believe inappropriate anger took place. The offender may start with no time with the children until certain conditions of the court are met. Then they may be required to have professionally supervised visitation. If they are successful, they may get limited time during a day and transition to an occasional overnight. More if the offender demonstrates that they have learned what to do and can give examples of how they implement those skills into their life. If they fail to do what is required of them, or not take responsibility for the inappropriate behavior, the process will continue until they do so or choose to no longer participate. Most times after violence in the home, the court will also issue a no-contact restraining order to protect the victim and the children. If the victim chooses to allow the offender back into the home after the court tells the victim not to, they may also be choosing to lose the children for failure to protect and not get them back until they satisfy court requirements that prove they have the knowledge and skills to provide a stable home for the children. I'm not an attorney, but these are some of the penal code laws in California that could require intervention or involvement in an anger management program or domestic violence program. Could involve CPS, Child Protective Services, or family court may, if they've someone has been arrested for this, even if they weren't convicted of these things, may require therapy. Oftentimes, a person could be arrested for numerous counts of similar kinds of violations, and those are oftentimes used when the plea bargaining takes place as a way to satisfy both the community with the district attorney's office and with the person who is the offender in these cases. Penal Code 273.5 is corporal injury to a spouse or a cohabitant. It says that it is illegal to inflict a corporal injury resulting in a traumatic condition. A person commits this crime by striking his or her intimate partner in some violent way and causing a visible injury, even a slight one such as swelling or a bruise. This California domestic violence law can be charged if the alleged victim is a current or former spouse or cohabitant, or the parent of your child. Domestic battery is Penal Code 243E1. The legal definition of domestic battery is any willful and unlawful touching that is harmful or offensive and is committed against the defendant's spouse or former spouse, the defendant's cohabitant or former cohabitant, the defendant's fiancé or former fiancé,
a person with whom the defendant has or used to have a dating relationship, or the father or mother of the defendant's child. A defendant can be convicted of domestic battery, sometimes known as spousal battery, even if the victim is not injured in any way. All that's required is that the defendant use force or violence against him or her. This distinguishes domestic battery from the related domestic violence offense, which requires that the victim suffer some form of physical injury.
Penal Code 240 is assault. Assault is an unlawful attempt coupled with a present ability to commit a violent injury on the person of another. It means you willfully acted in a way that would likely result in application of force to another. You were aware that act would likely result in application of force, and you had the present ability to cause application of such force. Penal Code 242 is battery. A battery is any willful and unlawful use of force or violence upon the person of another. You willfully used force or violence upon another. Penal Code 243D is aggravated battery. It means you willfully used force or violence upon another, causing serious bodily injury. Oftentimes, this has an attachment to it called a GBI. It means great bodily injury. That's an enhancement to the crime and can mean that somebody has to either do more time, pay more fines. There's more serious consequences with a intent to do great bodily injury. Penal Code 245A1 is assault with a deadly weapon. It means you assaulted someone with a deadly weapon or with other means of force likely to cause great bodily injury. Penal Code 422 is criminal threats. It's any person who willfully threatens to commit a crime which will result in death or great bodily injury to another person, with the specific intent that the statement made verbally, in writing, or by means of an electronic communication device is to be taken as a threat, even if there is no intent of actually carrying it out, which, on its face and under the circumstances in which it is made, is so unequivocal, unconditional, immediate, and specific as to convey to the person threatened a gravity of purpose and an immediate prospect of execution of the threat, and thereby causes that person to be in sustained fear for his or her own safety or for his or her immediate family safety, shall be punished by imprisonment in the county jail. I want to say that on this one, there's a lot of people that do get arrested for criminal threats, it's one of the counts that they may be arrested for, and oftentimes it may be a neighbor or a relative who heard the argument taking place, and they were the ones that called the police and made a report that becomes the justification for this being one of the counts held against that individual. Penal Code 236 and 237 is false imprisonment. False imprisonment is the unlawful violation of the personal liberty of another. The defendant intentionally restrained or confined another person by violence or threats of violence, or the defendant made the other person stay in the confined place or made the victim go somewhere without the victim's consent or without legal justification. Stopping someone from calling for help is PC 136 or PC 591.5. A person commits a public offense if the person knowingly and maliciously interrupts, disrupts, impedes, or otherwise interferes with the transmission of a communication over an amateur or citizens band radio frequency, the purpose of which communication is to inform or inquire about an emergency. Emergency means a condition or circumstance in which an individual is or is reasonably believed by the person transmitting the communication to be in imminent danger of serious bodily injury, in which property is or is reasonably believed by the person transmitting the communication to be in imminent danger of extensive damage or destruction, or in which that injury or destruction has occurred and the person transmitting is attempting to summon assistance. Penal Code 646.9 is stalking. It's defined as any person who willfully, maliciously, and repeatedly follows or harasses another person. and who makes a credible threat with the intent to place that person in reasonable fear for his or her safety or his or her immediate family's safety.
Children's Protective Services gets involved when there are claims that a child or children are at risk. The investigator conducts a comprehensive evaluation of risk and protective factors that include child safety, family strengths and needs, history and impact of prior child abuse or neglect, domestic violence or substance abuse, and family connections. The investigation is usually completed within 30 days, and a determination is made to close the case, close and refer the case to community providers, or open the case for ongoing protective services. If there is a need for a referral, CPS may recommend one or more of the following: a relapse prevention program, a parenting class, a co-parenting class, a child development class, an anger management class, a batter's treatment program, individual, couples, or family counseling, or any other program thought to be beneficial for the family. A common concern is, how do I work, take care of my health, help my children, and go to all these programs and pay for it? Although this may be a legitimate concern, families wanting their children back somehow figure out a way to make it happen. Family court can get involved when there is a custody case. Often one or both parties allege that inappropriate anger has taken place in the home and that the children were affected by the anger. Sometimes one party will say CPS was involved. The other party will agree but say the case was closed. When CPS is called, they may say that there wasn't enough evidence to open a case, but there was enough information for them to have concerns. Upon further questioning, the court may determine that this information is based on the more convincing evidence and its probable truth or accuracy, and not on the amount of evidence, and is therefore going to order that one or both parents get involved in some kind of counseling.